Those state legislatures which do not have a council for the time being, they can pass a resolution asking the parliament to pass a law by simple majority to create one. बट वो रेजोल्यूशन जो पास होगा आपके लेजिस्लेटिव असेंबली में पास होगा और स्पेशल मेजॉरिटी से पास होगा, तब पार्लियामेंट में जाएगा, पार्लियामेंट उसे पास कर लेंगे अंडर आर्टिकल 169 एंड दैट विल नॉट बी कंसिडर्ड एज एन अमेंडमेंट अंडर आर्टिकल 368. इट मींस अगर वाइस वर्सा इज द केस, if it is passed by the legislative council and goes to the assembly rejects it, the bill is dead. So you can understand there is no scope of joint sitting. स्टेट लेजिस्लेचर, और अब आप देखोगे कि हमारा काम बड़ा आसान हो गया क्योंकि हमने सब कुछ पढ़ चुके हैं यूनियन लेजिस्लेचर के बारे में. स्टेट लेजिस्लेचर में 95% चीज़ें वैसी हैं, थोड़े से चेंजेस हैं इधर उधर, एंड विल हैव अ लुक एट इट. लेट्स गो टू द स्टेट लेजिस्लेचर. सो आर्टिकल 168 to 212 in part 6 of the Indian Constitution deal with the organization, composition, duration, officers, procedures, privileges, powers and so on of the state legislature. There is no uniformity in the organization of state legislature. जैसे यूनियन लेजिस्लेचर बाइकैमरल है, हर स्टेट लेजिस्लेचर बाइकैमरल नहीं है, कुछ यूनिकैमरल है, कुछ बाइकैमरल है. At present, which is in 2019, but now in 2020 also, you can say only 6 states have 2 houses which are bicameral legislature. These are Andhra Pradesh, Telangana, Uttar Pradesh, Bihar, Maharashtra and Karnataka. बाकी हर जगह you have unicameral legislature. In the states having bicameral system, the state legislature consists of the governor, the legislative assembly and the legislative council. So you can understand that most of the states have governor and legislative assembly, but 6 states have governor, legislative assembly and the legislative council. Legislative council you can consider a kind of elders house at the state level, but it is not like the Rajya Sabha. Its powers are also very less when you compare it with Rajya Sabha and vis-a-vis the center and the state, as the case might be. The legislative council, Vidhan Parishad, is the upper house, second chamber of the House of the Elders, while the Legislative Assembly or the Vidhan Sabha is the lower house, first chamber or the popular chamber, very much similar to the Lok Sabha at the center. The Constitution provides for the abolition or creation of the Legislative Council in states. अब देखो, Rajya Sabha is a permanent member, permanent body or permanent chamber rather. It is not subject to dissolution, but Legislative Council को तो आप dissolve भी कर सकते हो, dissolve क्या abolish भी कर सकते हो. So, sorry, you cannot dissolve it, but you can abolish it. So, keep this in mind. Accordingly, the parliament can abolish a legislative council where it already exists or create one where it does not exist if the legislative assembly of the concerned state passes a resolution to that effect. Such a specific resolution must be passed by the state assembly by a special majority. That is a majority of the total membership of the assembly and the majority of not less than 2/3 of the members of the assembly present and voting. But you know that when this is done, it is not considered as an amendment to the Constitution. This Act of Parliament is not to be deemed as an amendment to the Constitution for the purposes of Article 368 and is passed like an ordinary piece of legislation, that is by simple majority. In simple word, that those state legislatures which do not have a council for the time being, they can pass a resolution asking the Parliament to pass a law by simple majority to create one. बट वो रेजोल्यूशन जो पास होगा आपके लेजिस्लेटिव असेंबली में पास होगा और स्पेशल मेजॉरिटी से पास होगा, तब पार्लियामेंट में जाएगा, पार्लियामेंट उसे पास कर लेंगे अंडर आर्टिकल 169 एंड दैट विल नॉट बी कंसिडर्ड एज एन अमेंडमेंट अंडर आर्टिकल 368. इट मींस बाय ऑर्डिनरी लेजिस्लेटिव प्रोसीजर एंड बाय सिंपल मेजॉरिटी. डू यू अंडरस्टैंड दिस? You can also abolish the existing legislative council. It means you can create, you can abolish, you can bring it to life, you can demolish it any moment you want. Composition of the Legislative Assembly. Now, let us have a look at the strength of the Legislative Assembly. The Legislative Assembly consists of representatives directly elected by the people on the basis of universal adult franchise, territorial constituency, वो सारी चीजें, we are not repeating that. Its maximum strength is fixed at 500 and minimum strength at 60. It means that its strength varies from 60 to 500 depending on the population size of the state. Not necessary for you to read about every state or kitni seat hai, but at least for your home state you should know about it. However, in case of Arunachal Pradesh, Sikkim and Goa, the minimum number is fixed at 30, and in case of Mizoram and Nagaland it is 40 and 46 respectively. Further, some members of the Legislative Assembly in Sikkim and Nagaland are also elected indirectly because of this tribal issue, you can understand, to give representation to them. Nominated member जो एक कर सकते हैं लेजिस्लेटिव असेंबली में, अब वो है नहीं क्योंकि 104th कॉन्स्टिट्यूशनल अमेंडमेंट ने उसे हटा दिया है. टेरिटोरियल कॉन्स्टिट्यूंसी, आई एम नॉट रिपीटिंग इट, यू नो दैट एंटायर स्टेट इज डिवाइडेड इनटू जियोग्राफिकल units, and every geographical unit is treated as a territorial constituency and the seats are given to that constituency on the basis of population. Clear? So parity is maintained as far as the seats allocated to different territorial constituencies. It's very much similar to that of the Lok Sabha territorial constituency. Readjustment after every census. Let's have a look at this. After each census, a readjustment is to be made in the total number of seats in the assembly of each state and the division of each state into territorial constituencies. The parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, parliament has enacted a delimitation commission. वो सारी चीजें जो हम पहले ही देख चुके हैं, so no need of repeating it one more time. But keep this in mind that this has been it has been frozen 2026 to encourage population control measure, and then you will see that there would be further readjustment thereupon. Reservation of seats for SCs and STs. The constitution provided for the reservation of seats for scheduled caste and scheduled tribe in the assembly of each state on the basis of population ratios. Originally this reservation was to operate for 10 years, but you know, by the 104th constitutional amendment, which abolished not only the Anglo-Indian membership, but it also extended the reservation for the members of the scheduled caste and scheduled tribe in the legislative assembly for another 10 years, and now it will extend till 25th of January 2030. So keep that also in mind. Now what is the composition of the legislative council? This is something important that we need to learn. Unlike the members of the Legislative Assembly, the members of the Legislative Council are indirectly elected. The maximum strength of the council is fixed at 1/3 of the total strength of the assembly, and the minimum strength is fixed at 30. It means it cannot go beyond 1/3 and it cannot fall below 40. It means that the size of the council depends upon the size of the assembly of the concerned state. This is done to ensure that the predominance of the directly elected houses assembly in the legislative affairs of the state is maintained. Though the constitution has fixed the maximum and the minimum limits, the actual strength of the council is fixed by the parliament. Anyhow, let's have a look at this manner of election. Of the total number of members of the legislative council, we are talking about the Vidhan Parishad, not the Vidhan Sabha. 1/3 are elected by members of the local bodies in the state like municipalities, district boards, etc. 1/12 are elected by graduates of 3 years standing and residing within the state. It means to give representation to the graduates. 1/12 are elected by the teachers of 3 years standing in the state, not lower in standard than the secondary school. 1/3 are elected by the members of the legislative assembly of the state from amongst persons who are not members of the legislative assembly. तो उनको वो काउंसिल में भेजते हैं. The remainder are nominated by the governor from amongst persons who have special knowledge or practical experience of literature, science, art, कोऑपरेटिव मूवमेंट एंड सोशल सर्विस. तो बस सेम है जैसे प्रेसिडेंट नॉमिनेट करते हैं राज्यसभा के लिए, पर यहाँ पे एक स्पेशल ग्राउंड है जो आप ध्यान में रखना, कोऑपरेटिव मूवमेंट, दैट इज नॉट प्रेजेंट इन द नेशनल लेवल. Thus 5/6 of it of total number of members of the legislative council are indirectly elected and 1/6 are nominated by the governor. The members are elected in accordance with the system of proportional representation by means of single transferable vote. तो जहाँ पे भी indirect election आएगा, ये system हमने adopt किया है, single transferable vote और proportional representation. The bona fide or the property of the governor's nomination in any case cannot be challenged in the court. So keep that thing in mind. Duration of the houses, duration of assembly, like the Lok Sabha, the legislative assembly is not a continuing chamber, but its normal term is 5 years, but it can be dissolved earlier as well. The expiration of the period of 5 years operates as an automatic dissolution of the assembly. However, the governor is authorized to dissolve the assembly at any time, that is even before the completion of the 5 years, to pave the way for fresh election. For the term of the assembly can be extended during the period of national emergency by the law of a parliament for 1 year at a time. Remember, this cannot be done by the state legislative assembly, but by a law of the parliament, and 1 year at a time, but not beyond 6 months from the date in which the emergency itself has ceased to operate. Duration of the council, like the Rajya Sabha, the legislative council is a continuing chamber, so it cannot be dissolved, but it can be abolished, unlike Rajya Sabha. That is, it is a permanent body and is not subject to dissolution. So ये ध्यान रखना, dissolve तो नहीं हो सकता, but हाँ, abolish जरूर हो सकता है. But 1/3 of its members retire on the expiration of every second year. So a member continues as such for 6 years. The vacant seats are filled up by fresh elections and nominations by the governor at the beginning of every 3rd year. The retiring members are also eligible for re-election and re-nomination any number of times. Qualification for the state legislature. What is the qualification? First, he must be a citizen of India. He must make and subscribe to an oath or affirmation before the person authorized by the election commission for this purpose. And what is the oath? To bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India. And third condition is he must not be less than 30 years of age in case of legislative council and 25 years of age in case of legislative assembly. सब कुछ same है union के जैसा. He must possess must possess other qualifications as prescribed by the parliament by law. So again, it is not by the state legislature but by the parliament. Power देना ही पड़ेगा, otherwise there would be no uniformity in case of administration or legislation. Accordingly, the parliament has laid down the following additional qualification for representation of people Act 1951. A person to be elected to the legislative council must be an elector for an assembly constituency in the concerned state, and to be qualified for the governor's nomination he must be a resident in the concerned state. Elector होना पड़ेगा अगर election के थ्रू जाना है और nomination के थ्रू जाना है तो आपको वहाँ पे resident होना पड़ेगा. A person to be elected to the legislative assembly must be an elector for an assembly constituency in the concerned state. तो ये council की बात हुई, यहाँ पर assembly में तो आपको elector होना ही पड़ेगा. He must be a member of the scheduled caste or scheduled tribe if he wants to contest a seat reserved for them. However, a member of the scheduled caste and scheduled tribe can also contest a seat not reserved for them. तो ये तो हम पहले ही पता था, ये दो नई चीजें हैं जो आप ध्यान में रखो. Let's now move at the disqualification of the state legislature. Same, the constitution says some grounds on which he would be disqualified, and then the parliament has made by law more or less similar. Let's have a quick look at it. Constitution says if he holds any office of profit under the union or state government except that of a minister or any other office exempted by the state legislature, if he is of unsound mind and stands so declared by a court, if he is an undischarged insolvent, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement or of allegiance to a foreign state, same hai. If he is so disqualified under any law made by the parliament, and parliament has therefore made a law and which talks about additional disqualification in the Representation of People's Act 1951, and these are the things that are mentioned. He must not have been found guilty of certain election offences or corruption practices in the election. He must not have been convicted for any offence resulting in the imprisonment for 2 or more years, but the detention of a person under a preventive detention law is not a disqualification. He must not have failed to lodge an account of his election expenses within the time. He must not have any interest in the government contracts, works or services. Now this is very difficult to establish. He must not be a director or managing agent nor hold an office of profit in corporation in which the government has at least 25% stake. He must not have been dismissed from government service for corruption or disloyalty to the state. He must not have been convicted for promoting enmity between different groups or for the offence of bribery. He must not have been punished for preaching and practicing social crimes such as untouchability, dowry and sati. On the question of whether a member has become subject to any of the above disqualification, the governor's decision is final. However, he should obtain the opinion of the election commission and act accordingly. Same जैसा central level पे है. Disqualification on the grounds of defection, वही same चीज़ है जैसे हम वहाँ पे भी हम डिफेक्शन के थ्रू डिस्क्वालिफिकेशन देख रहे थे, यहाँ पे भी यही अच्छी बात है पॉलिटी की कि एक बार अगर सेंट्रल लेजिस्लेचर पढ़ लिया तो वैसा ही है स्टेट लेजिस्लेचर, सेंट्रल एग्जीक्यूटिव पढ़ लिया तो वैसा ही है स्टेट एग्जीक्यूटिव. थोड़े से माइनर डिफरेंसेस है, वो आपको बस ध्यान में रखने हैं. The Constitution also plays down that the person shall be disqualified for being a member of either house of the state legislature if he is so disqualified on the ground of defection under the provisions of the 10th schedule. The question of disqualification under the 10th schedule is decided by the chairman in the case of the Legislative Council and Speaker in the case of Legislative Assembly and not by the governor. In 1992, Supreme Court said that their decision is final, though it is open for judicial review. Oath or affirmation. This is what every member takes oath: to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, and to faithfully discharge the duty of their office. Is either member of the state legislature before taking their seat, they make this oath. Unless a member takes oath, he cannot vote and participate in the proceedings of the House. ये एक important line है, आप ध्यान में रखना. And does not become eligible to the privileges and immunities of the state legislature. A person is liable to pay a penalty of 500 rupees for each day if he sits and votes as a member in a house. Before taking and subscribing the prescribed oath or affirmation, or when he knows that he is not qualified and is disqualified and still he is sitting, when he knows that he is prohibited from sitting or voting in the house by virtue of any law made by the parliament or by state legislature. मतलब 500 रुपये आपको हर दिन भरने पड़ेंगे अगर आपको ये पता है कि आपने ओथ नहीं लिया और फिर भी आप बैठे हैं, आप मेंबर नहीं हैं फिर भी आप बैठे हैं और वोट भी कर दिया है, या तो फिर आपको पता है कि आप डिस्क्वालीफाई हो गए हैं किसी ग्राउंड पे और फिर भी आपकी मेंबरशिप चली गई है बट स्टिल आपने छुपा के रखा है, समझ लो, देन 500 रुपीज़ का फाइन भरना पड़ेगा. बट 500 रुपीज़ तो आपको पता है कुछ भी नहीं है इनके लिए. बट द पॉइंट इज is all about electoral reforms and legislative reforms. That again falls into the category of mains examination. Members of a state legislature are entitled to receive such salaries and allowances as may from time to time be determined by the state legislature. Let's have a look at the vacation of seats, and I'm not repeating it one more time. We have already seen it: double membership, disqualification, resignation, absence without information, other cases. If the election is declared void by the court, if he is expelled by the house, if he is elected to the office of the president or the office of the vice president, if he is appointed to the office of the governor or of that of a state. डबल मेंबरशिप का मतलब यही है कि आप दोनों हाउस के मेंबर नहीं हो सकते. डिस्क्वालिफिकेशन कोई भी ग्राउंड पे जो हमने देख चुके हैं. Resignation: the member can resign his seat by writing to the chairman in the legislative council, speaker in the legislative assembly, as the case might be. Absence: a person who is absent from the state legislature can declare the seat of the member vacant if he absents himself from all his meeting for a period of 60 days without permission. मतलब 2 महीने तक अगर आप नहीं आए हो, then obviously your membership, your seat falls vacant. Speaker of the assembly. Now, speaker is elected by the assembly itself from amongst its members. Usually, the speaker remains in office during the life of the assembly. However, he vacates his office earlier in any one of the following 3 cases. First, if he ceases to be a member of the assembly, same as we have seen in the case of Speaker of the Lok Sabha. If he resigns by writing to the Deputy Speaker, if he is removed by a resolution passed by a majority of all the then members of the assembly, such a resolution can be moved only by giving a 14 days advance notice. So, exact replica. No need of explaining anything here, I feel. The Speaker has the following powers and duties. He maintains order and decorum in the assembly for conducting its business and regulating its proceedings. This is his primary responsibility, and he has the final power in this regard. He is the final interpreter of the provisions of the Constitution of India, the rules of procedure and conduct of business of assembly, and the legislative precedents within the assembly. It means everything, whatever happens within the confines of the assembly, the speaker takes a final call on it. He adjourns the assembly or suspends the meeting in the absence of a quorum. Again, 1/10. He does not vote in the first instance, but he can have a casting vote in case of a tie. He can allow a secret sitting of the house at the request of the leader of the house. He decides whether a bill is a money bill or not, and his decision in this regard is final. He decides the question on disqualification of a member of the assembly arising on the grounds of defection. As far as legislative council, it is chairman. He appoints the chairman of all the committees of the assembly and supervises the functioning. He himself is the chairman of the business advisory committee, the rules committee, and the general purpose committee. सब कुछ same है. So just keep that thing in mind, and this will automatically occur to you. Deputy Speaker of the Assembly. Like the Speaker, the Deputy Speaker is also elected by the Assembly itself from amongst its members. He is elected after the election of the Speaker has taken place. Like the Speaker, the Deputy Speaker remains in office usually during the life of the Assembly. However, he also vacates his office earlier in any of the following 3 cases: if he ceases to be a member of the Assembly, if he resigns by writing to the Speaker, if he is removed by a resolution passed by a majority of all the then members of the Assembly. Such a resolution can be moved only by giving 14 days notice in advance. So you can understand, again, by effective majority and all of that. The Deputy Speaker performs the duties of the Speaker office when it is vacant. He also acts as the Speaker when the latter is absent from the sitting of the Assembly. In both the cases, he has all the powers of the Speakers. In temporary absence, permanent absence, he behaves as the Speaker. The Speaker nominates from amongst the members of a panel of chairmen. Any one of them can preside over the assembly in the absence of the Speaker and the Deputy Speaker. He has the same powers as the Speaker when so presiding. He holds office until a new panel of chairmen is nominated. So, जैसे panel of chairmen वहाँ पे था लोकसभा में, यहाँ पे भी है. Let's have a look at the chairman of the council. यहाँ पे चीजें थोड़ी different है. When you talk about the Rajya Sabha and you're talking about the vice president, he is not a member of the Rajya Sabha. Is the ex officio chairman. Whereas when you talk about the legislative council, let's see the difference. The chairman is elected by the council itself from amongst its members. It means the chairman is also a member of the legislative council. The chairman vacates his office in any of the following 3 cases. Let's have a look at this. If he ceases to be a member of the council, if he resigns writing to the deputy chairman, and if he is removed by a resolution passed by a majority of all the then members of the council, such a resolution can be moved only by serving a 14 days notice in advance. As a presiding office, the powers of the functions of the chairman in the council are similar to that of the speaker in the assembly. However, the speaker has one special power which is not enjoyed by the chairman. And what is it? The speaker decides whether a bill is a money bill or not, and his decision on this question is final. Joint sitting की बात क्यों नहीं हो रही है? Because there is no question of joint sitting at the state level. We'll see this. Let's have a look at this. The salaries and allowances of the speaker, the deputy chairman of the assembly, deputy speaker of the assembly, and the chairman and deputy chairman of the council are fixed by the state legislature. They are charged on the consolidated fund of the state, not of India, and thus are not subject to the annual vote of the state legislature, because the state also has a state budget or something like that. Deputy chairman of the council, like the chairman, the deputy chairman is also elected by the council itself from amongst its members. He vacates his office in any of the three ways: if he ceases to be a member of the council, if he resigns by writing to the chairman, if he is removed by a resolution passed by the majority of all the then members of the council. Such a resolution can be moved only after giving a 14 days notice in advance. The deputy chairman performs the duties of the chairman office when it is vacant. He also acts as the chairman when the latter is absent from the sitting of the council. In both the cases, he has all the powers of the chairman. The chairman nominates from amongst the members a panel of vice chairmen. Any one of them can preside over the council in the absence of the chairman or the deputy chairman. He has the same powers as the chairman. When so presiding, he holds office until a new panel of vice chairmen is nominated. So again, very much similar. Let's have a look at the language that is used in the state legislature. Well, it should be the language of the state, but the speaker or the chairman or the deputy speaker or the deputy chairman, as the case might be, they can also allow the person to use some other language as well. Let's have a look at this. The constitution has declared the official language of the state or Hindi or English to be the languages of transacting business in the state legislature. However, the presiding officer can permit a member to address the house in his mother tongue. The state legislature is authorized, and this is mostly done by keeping in mind the aspirations of linguistic minorities. The state legislature is authorized to decide whether to continue or discontinue English as the floor language after the completion of the 15 years from the commencement of the constitution. But you know that has been continued. Legislative procedure in the state legislature. Now, we will take again ordinary bills and money bills here. So, ordinary bills, bill in the originating house, and ordinary bill can originate in either house of the state legislature. Now, look here, this is important to learn. If it is bicameral legislature, है ही नहीं तो फिर तो legislative assembly हो गया. Such a bill can be introduced either by a minister or by a member. It can be a government bill or it can be a private bill. The bill passes through all the three stages, that is first reading, second reading, third reading. I am not repeating it because we have already done that. After the bill is passed by the originating house, it is transmitted to the second house for the consideration and passage. A bill is deemed to have been passed by the state legislature only when both the houses have agreed to it, either with or without amendments. In case of a unicameral legislature, a bill is passed by the legislative assembly and is sent directly to the governor for his assent. But let's have a look at what happens in bicameral cases. Bill in the second house. In the second house also, the bill passes through all the three stages, that is first reading, second reading and third reading. When a bill is passed by the legislative assembly, अब यहाँ पर देखो, यहाँ पर change है. If it is passed by the legislative assembly and then transmitted to the legislative council, the latter has four alternatives. And what are they? First, it may pass the bill as sent by the assembly, that is without amendment. It may pass the bill with amendments and return it to the assembly for reconsideration, because we are talking about ordinary bills. It may reject the bill altogether, and it may not take any action, thus keeping the bill pending. Now look here, there was provision of joint sitting there, but here there is no such provision. If the council passes the bill without any amendments or the assembly accepts the amendment suggested by the council, the bill is deemed to have been passed by both the houses and it goes to the governor for his signification. On the other hand, if the assembly rejects the amendments suggested by the council, वहाँ पे अगर राज्यसभा के amendments को reject कर दिया लोकसभा ने, तो फिर तो joint sitting होगा. But here you see, on the other hand, if the assembly rejects the amendment suggested by the council or the council rejects the bill altogether, if the council rejects the bill or the assembly rejects the amendments made by the council, or the council does not take any action for 3 consecutive months, there in that case was 6 months, then the assembly may pass the bill again and transmit the same to the council. So look here, here is this overarching power of the assembly. This is what we are saying. कि जैसे बिल असेंबली से पास होकर काउंसिल में आए, काउंसिल कैन डू दीज थिंग्स. इट कैन पास द बिल, it can pass the bill with amendments, it goes to the assembly. Assembly does not recognizes the amendments and does not makes adherence with it. Second is council rejects it or takes no action for 3 months, not 6 months. In that case it was 6 months, 3 months. Then the council will again pass it. Sorry, then the assembly will again pass it. And once it will again pass it, and by simple majority, because it's an ordinary bill, you can understand, it will go back to the council again. And you see, If the council rejects the bill again or passes the bill with amendments not acceptable to the assembly or does not pass the bill within 1 month, then the bill is deemed to have been passed by both the houses in the form in which it was passed by the assembly for the second time. मतलब second time जब वो फिर से पास होकर आया legislative council के पास, अब legislative council क्या कर सकते हैं? अगर उसने reject किया तो तुरंत वो माना जाएगा पास हो गया. Second, if the legislative council does this, that it makes amendments and it is again not acceptable, still it would be considered as passed. And third is if it takes action for no action for consecutive 30 days, it is 1 month. It means maximum time जो आप hold कर सकते हो as in the council, a bill which is passed by the legislative assembly is 4 months. There is no scope of joint sitting. Therefore, the ultimate power of passing an ordinary bill is vested in the assembly. At most, the council can delay or detain the bill for a period of 4 months, 3 months in the first instance and 1 month in the second instance. The constitution does not provide for the mechanism of joint sitting of both the houses to resolve the disagreement between the two houses over a bill. When a bill which has originated in the council and was sent to the assembly is rejected by the assembly, the bill ends and becomes dead. It means agar vice versa is the case, if it is passed by the legislative council and goes to the assembly, assembly rejects it, the bill is dead. So you can understand there is no scope of joint sitting. Assent of the governor. Every bill after it is passed by the assembly or by both the houses in case of bicameral legislature is presented to the governor for his assent, and the governor has 4 alternatives. ये भी हम देख चुके हैं. He can give his assent, he may withhold his assent, he may return the bill for reconsideration if it is not a money bill, since it is an ordinary bill, so he can return it. He may reserve the bill for the consideration of the president. When he reserves the bill for the consideration of the president, it is a discretionary power, but in one case he has to do it when the bill in question is derogatory to the powers of the High Court of the state concerned. Once the bill is reserved, the president may again return the bill through the governor for the reconsideration of the house. If the house passes again, it is not binding on the president to give his assent in the second time as well. So if the governor gives his assent to the bill becomes an act of the parliament, is placed in the statute book. If the governor withholds his assent to the bill ends and does not become an act. If the governor returns the bill for reconsideration and if the bill is passed by the house or both the houses again with or without amendments and presented to the governor for his assent, the governor must give his assent to the bill. Thus the governor enjoys only a suspensive kind of veto. Assent by the president. When a bill is reserved by the governor for the consideration of the president may either give his assent to the bill or withhold his assent or return the bill for reconsideration of the house or the houses of the state legislature, because it can be unicameral, bicameral, anything. When a bill is so returned, the house or the houses have to consider it within a period of 6 months. This is what you need to keep in mind. The bill is presented again to the presidential assent after it is passed by the house or houses with or without amendment. It is not mentioned in the constitution whether it is obligatory on the part of the president to give his assent to such a bill or not. So you can understand this is straight disapproval of state legislation by union executive.